Will provisions. The first provision you'll see in the will is called the exordium clause, and it's this exordium clause that identifies the testator, identifies the testator's domicile, at least as of the time of the making of the will, and the testator also in this exordium will expresses his or her testamentary intent, that it is by this document that they are distributing their property upon their death. And then the very important part of the exordium clause is what we call the revocation clause. It's a sentence in the clause. It reads something like this: I hereby revoke all wills and codicils previously made by me. And what that does is have the effect of wiping the slate clean and saying, this is my will. It's nothing that's come before. This is it. Because we don't want to get in a situation of trying to determine, well, which will, if for some reason they're not dated, which will came first, or if they are dated, if you got a conflict between the two documents, trying to interpret that conflict between the two. It's just easier to start off fresh, say, I hereby revoke all wills previously made by me. Debts and expenses, that's a provision that you'll frequently see in the will. It's frequently not needed because state law of all the states is going to require that the debts and expenses of the testator are paid before the assets are distributed to those who take them under the will. You also run the danger of the phrase suggesting or directing that otherwise uncollectible debt may suddenly be collectible and should be paid. So we have to be very careful with the use of that, but once again, that's an item for the attorneys to watch out for, but you will commonly see debts and expenses in the will. Funeral arrangements, that's not a good idea to put that in the will, but you're frequently going to see it. People will want to have that in the will, but that's really the best place to put it is in a letter of instruction to the loved ones and to have those conversations with the loved ones. We don't want any uh-oh moments after the cremation to realize that they wanted a certain type of funeral. And so really the funeral arrangements, it's not a good idea to put it there. The heart of the will is the dispositive provisions, where we're actually disposing now of the property. Specific bequests are usually found first in the list because we there have maybe certain things certain specific pieces of property we want to go to certain specific people. And that's why we call it a specific bequest. Now, the next one is general bequest. Now, general bequest is going to be more broad, and it's the bulk of the estate. I give my estate to my children, A, B, and C, or I give all my estate to my spouse, Sally Jones, provided she survives me by X number of days, and we'll get to that reference to days in just a moment. So, but that's the general bequest. We also need to consider alternates, that in the event the recipient of the general bequest predeceases the testator's already thought ahead and say, okay, if that person predeceases me, then I want my general bequest to go to so-and-so. Residuary clause. Residuary clause is kind of a catch-all clause. It makes sure that everything that the testator has is going to pass to beneficiaries. And it will read something like, I give the rest and residue of my estate to blank. Now, it sounds like a general bequest, and it basically is. Frequently, sometimes you won't see both a residuary and a general bequest both at the same time, sometimes because the way both of them are worded, everything is covered. And so the general bequest may be written in such a way that it really becomes the residuary clause. But when you look at a will, always look to see, is there a possibility of any gifts hanging out there that haven't been given if for some reason they lapsed and weren't picked up by the general bequest clause or a residuary clause. Survival, simultaneous death is what I mentioned just a few minutes ago. The testator is saying, so-and-so gets this gift if they survive me by a certain number of days. Frequently you'll see 30 days, it may be 45 for some attorneys. Some attorneys may want 6 months, 60 days. It could be anything. The Uniform Simultaneous Death Act covers that as well, and it's been adopted in all the states. So even if it's not mentioned in the will, there is a time period that all the states are going to observe. Memorandum. Sometimes the testator, testatrix will want to leave certain property, small items, jewelry, maybe a piece of furniture or heirloom or something like that to specific people. And the list may be so lengthy and may change because of the nature of the dynamics of the family or whatever. Sometimes it's not unusual for a testator or testatrix to say, if I have left or I may have left or if I do leave a memorandum in my own handwriting setting out specific items that I want to go to certain people, that I ask that the executor honor that and make those gifts. It's really not the same thing as incorporating by reference, because when you have another document on the outside of the will and you want to make that part of the will by incorporating it and referring to it and say, I'm incorporating it into the will. Well, that document, that outside third document or second document becomes a part of the will, provided it was already in existence. Well, the deal with the memorandum, frequently they're not already in existence. That someone may change that list over time. Miscellaneous provisions. Very important that we define the meaning of the word children. It's generally understood to include adopted children, but depending on the way the will is worded, you have to be very careful, and you may want to be very sure that adopted children, if that is the case, either are or not. Some people, it's their will, they can write their will however they want, but it may be very important that we have a clear understanding of what is meant by the word children. So we'll define it. And there may be some other terms that we'll define as well in a particular will. Disinheritance. You might see that, someone disinheriting or saying so-and-so is not going to take anything under my will. I'm not making a provision for so-and-so in my will intentionally. They may or may not give a reason. Different lawyers have different thoughts about that. I don't like giving a reason. If my client wants to disinherit someone, I say I hereby I intentionally make no gift for so-and-so. And that takes care of it. My client doesn't have to explain the reasons. But you may see that. No contest provision, they're not always needed. You may see them from time to time, and sometimes they're ineffective. The whole idea is that you're trying to encourage someone who would be maybe an heir, go along with the will and not try to contest it and knock the will down. Sometimes it works, sometimes it doesn't. Hopefully the family dynamics are such that you wouldn't even have to have a clause, but sometimes you'll see it. Fiduciary provisions. Here we will be appointing the executor, that's the personal representative of the testator, testatrix. We'll also appoint somewhere in the will the trustee, and then also guardians. Let's go back to executor. In many states, and Texas is among them, we have a situation where we can have an independent administration of the estate, but we have to set that out in the will. And what that means is the court will have, probate court will have minimal supervision over the estate. And that's a very good situation. It holds down costs. So you may frequently see I direct that my executor have broad powers and be free of court control, something like that, or actually use the word independent. We also have the issues of, is a bond going to be required to protect the beneficiaries from any wrongdoing by the executor? What about a fee? Is my executor going to get paid? And the same, and then of course whatever the powers are. And so those also apply to the trustee as well. Trustee, that will be someone who holds property, frequently for a minor person, a child, to hold them and hold the property for them and manage it for certain purposes until that person reaches whatever age is set out in that testamentary trust. The important thing is whether this testamentary trust does, for minors, it avoids a guardianship of the estate, which would involve some very close court supervision of the child's money. So that's why we'll frequently see a trustee with a trust. Guardian, parents can appoint in their will guardian of the person of their children. And they could appoint a guardian of their children's property, or what we call estate, guardian of the estate. But that's why we're doing a trust with a trustee, to avoid that. But the parents can appoint and should appoint in their will a guardian over their children, the persons of their children. All right, and we've been talking about contingent trust for the children. Let's look at this a little bit more carefully for just a moment. We're going to have a trustee. We need to think about alternates. So when in the provision, be thinking about alternates. Ask the testator, testatrix, if so-and-so can't serve, who would you want as a backup? The contingent trust will have powers for the trustee. And usually these are very, very broad powers to keep it free of court control. And so the trustee is acting as the creator of the trust would have. Distributions. When are we going to distribute any money or property from the trust? Is it going to be just from the interest, or can it be from the body or the corpus of the trust as well? Under what circumstances does it happen? Is it for the health and education and support of the children, or for something else, or for maybe just a few of those? So we have to state what those expenditures can be for and what the purpose of the trust is. When do these distributions come? Are they going to be periodic at certain times? We have to state what those are. Or is it going to be lump sum perhaps at the end of the trust? And when does that trust end? What's the termination? What do we do it? Tie it to an age of the children or the beneficiaries of the trust, or is there going to be some other event that's going to trigger the termination of the trust? So these are provisions that you'll commonly see in a testamentary trust. And when we do our interviews, we want to touch these points. And when we're looking at the will after the fact, these are the things we're going to be looking for. And then finally, ending provisions. We have a testimonium clause, and that's the clause that the testator signs saying, I am the testator and this is my will, hereby signing it before these witnesses. Attestation clause is the clause signed by the witnesses, and they say, we're signing this will as witnesses in the presence of the testator. And these are signed and dated. Then in many documents, many states, depends on state law, there'll be a self-proving affidavit, where the will proves itself. And that happens because a notary takes an affidavit of the testator and the 2 or 3 witnesses, whatever you have, and where they're all swearing that everything was done properly, everybody's got proper capacity, and everything was properly done. And then the judge will take that as evidence at the probate hearing and not require these witnesses to attend, because the judge has the evidence in front of him or her. That self-proving affidavit may be embedded in the testimonium and attestation clauses, or it may be a separate standalone self-proving affidavit. And that's an overview of will provisions.